A California law is at the heart of this case. It requires pro-life crisis pregnancy centers to post information on abortion services.
This is a warm and inviting place.
Josh McClure started the pregnancy care clinic in San Diego.
This is our exam room.
In 2015, he first heard about the bill that would force him to post an abortion sign. He immediately began plans to protest at the state capitol.
We quickly realized that it was being fast-tracked and moved through very quickly, and that they were very set on getting it passed.
And lawmakers were successful. Here's exactly what the state's medically licensed pro-life pregnancy centers must communicate. California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, prenatal care, and abortion for eligible women. To determine whether you qualify, contact the county social services office at. The notice must either be posted in pregnancy center waiting rooms or made available digitally or on paper.
It sends a mixed message. It sends a confusing message.
McClure calls the mandate outrageous. It's why he and other California pregnancy centers are taking their fight to the Supreme Court.
It's kind of like the American Lung Association being forced by the government to promote cigarettes. It's contrary to what they believe.
Ann O'Connor represents the clinics and says this is bigger than abortion. It's about how Americans are protected under the First Amendment.
If the government can tell us what we have to say, even when it's opposed to why we exist, then everybody is vulnerable, not just pregnancy centers.
The state of California argues this is about the more than 700,000 women who become pregnant each year, half of whom did not intend to become pregnant. It also states many low-income women don't know about free or low-cost public programs, including abortion. The liberal Ninth Circuit upheld that thinking, ruling the abortion notice helps in safeguarding public health and fully informing Californians. But Kevin Terrio, who also represents the clinics, maintains it goes beyond the facts and actually serves as an advertisement.
They are presenting it as a viable option by, if they have it on their wall of the waiting room, they may not even get a chance to explain how they counsel women regarding the three options and what their views are on abortion before they say, oh, I could just call and get a free or a reduced cost of abortion. I might as well do that.
The Ninth Circuit justifies the law as a professional speech regulation. It also cites among the state's concerns that crisis pregnancy centers often confuse, misinform, and even intimidate women from making fully informed, time-sensitive decisions. O'Connor says it's just the opposite.
These centers are very clear what they do, and they're safe havens for women who are being bombarded with other messages.
More than 2,500 centers serve pregnant women and new moms around the country. They provide a range of free services, including counseling, ultrasounds, parenting classes, and clothes for both moms and babies. Many are also licensed medical facilities, which means they can offer pregnancy testing and the all-important ultrasound. O'Connor says these services not only confirm a woman's pregnancy, but they also allow her to see her child.
It just opens doors, and when women see that, they go, oh, I could never have an abortion.
However the court decides in this case, its decision has the potential to affect not only thousands of crisis pregnancy centers around the country, but how we understand what is allowed and not allowed to be said in the workplace. Reporting in San Diego, Heather Sell, CBN News.